And we're here for another edition of Fire Law Roundup for October 16th of 2023. Brad, go ahead. Take us.
Let's start in Mississippi. Let me make clear before I go through these very, very familiar facts. These are allegations. This is a charge, so there's no finding of guilt. Everyone's presumed innocent, I suppose. But a Mississippi firefighter is now facing felony embezzlement charges from stealing from the Firefighters Association, which we think may be the union, not the fire company. We're not 100% sure, but I think that's what your thought is.
I don't think it's, I think whether it's a union, like some places down south don't have like an IAFF local, but they have an association because they can't bargain. Mississippi's got some collective bargaining, I believe. I believe, I'm not 100% sure, because I know I've been down in New Orleans. I've met with the New Orleans firefighters, and I know they have a union, IAFF local there. But in terms of bargaining, I'm not sure that they have the ability to bargain. So I'm guessing it's more in the nature of a fraternal organization, not a bargaining agent, but nonetheless.
Either way, we got a 28-year-old who, is accused of, not found guilty of, accused of stealing, embezzling. He was the treasurer for the association. First, he was placed on administrative leave. Then he was fired. The chief came out, if the chief was my client, chief, if you're listening, my 2 cents is I would have couched my statement a little more cautious to avoid some potential defamation claims if it turns out this person doesn't plead guilty or isn't found guilty. But what the chief does is good for the community, right? He's saying it's bothersome for me that this former employee, because they fired him, chose to forego the opportunity to ask for help from his OSFD family who trusted and respected him, but rather he chose to betray all of us by making a repetitive, conscious decision to steal. Now, I'm presuming they've caught him, but again,
I think he admitted it. One of the things that I read, there's a number of articles, but I think he basically admitted it.
Okay.
So now whether he attributed to some other issue that he may have, that when the chief said that it's bothersome that he didn't ask for help.
Well, that gives us a clue.
It does, so. But
I have a saying, I've probably said it on this show a million times. Bad times make good people do bad things. And I believe it. And that's what this kind of quote from the chief makes it sound like. That the treasurer was having some problems, saw there's some money there. Maybe he intended to return it, but that never happens. You dig a hole, you just keep digging. And he just kept taking, apparently, allegedly. So I caution people. This is just our repeating record, but I want to caution. Right. So you may trust with your life, your treasurer. That's fine. However, you don't know what's going on in their lives or their lives of their family. Maybe their wife is sick and they don't have health insurance. Maybe you don't know. Bad times make good people do bad things. And maybe that's what happened here. It's not about trust. You need to regularly review bank statements and audit bank statements. We can teach you as a person how to do this. Look, I have a checklist where I have a checklist to tell people how to do this and what to look for. A union or association probably doesn't have that much money or that many expenses every day where there's that hard to look at bank statements. You got to look. It's not about trust. It's right. If your treasurer is insulted that you ask to review bank statements and things like that, then they're probably stealing in the first place. Nobody should be insulted that you want to look over their work, but you cannot leave one person in charge of all this money and never look at what they're doing.
Yeah, it's just too big. It's too big a temptation for some people. Some people, they could be tempted at any time. Some people might have to be in a very bad place in their lives. Or have some other issues, and then that is, like you suggest, causes somebody who might not otherwise be inclined to do it. If we have the systems in place, they're less likely to do it. Right. And again, 2 areas where we see this. We see much more of this on the volunteer side, but we do see it in firefighter unions and other types of charitable events that firefighters end up, getting money from the community, and the money's intended to do the right thing for the organization, but Some people are in a position in their lives, or some people just have that, what psychologists call it the antisocial personality. I don't think that's not our bigger concern. Is somebody gets themselves in a situation and they see this as an option, and we've got to close that door.
Right. And what I don't understand, this will be the last thing I say about it, but what I don't understand is the fire service is so good on, like, firefighter close calls and things. We're so good about learning from our mistakes and creating education and investigations. And we're so good about looking into how to not let things happen again. Yet this one never is cured. Why aren't fire departments having their and unions, et cetera, having their books looked at? And it doesn't have to be an accountant who does a formal audit. We do these things all the time for our clients, where we go through the records, you look at the bills and the checks and the statements, and it will jump out at you unless they're really trying to hide something. Most of these are just straight checks written to somebody's self, or to their own, or to cash, or to whoever they owe money to. It is not that hard to find most of these. I don't understand why people don't look. Stop trusting your treasurer. A trustworthy treasurer does not want to be trusted. They want to be treated like they're not trusted, right? They would be like, look at everything I got. Happy to have you look. It gets me off the hook. Why are we doing this? Why are we blindly anyway, stop. Everyone needs to stop. Okay. Let's go to the 11th Circuit. Let's go down to Florida. Now, this is a really long decision I'm going to make. I can summarize, but this is really interesting. I'll explain the issue, but this is really interesting because what people need to understand here is the court says we are split. So in law, for our viewers, we have something called stare decisis. We have to follow the law. We have to follow the precedent. So there might be a statute which gives law, but then there's interpretations of the statute. And because it's an interpretation, courts can vary on their interpretations. Here we have higher level courts admitting that throughout the nation, there are different ways of viewing the law, of interpreting the law. So the question here is, we have a retired Florida firefighter who says that he was discriminated against as a result of a disability. Very important to note disability discrimination, because as the court says at the end, a disability is not a protected class. So that gets rid of a lot of other laws where somebody could sue on the basis of gender, race, things like that. So disability here, the way they sue is saying, listen, I was discriminated against in my employment. However, this firefighter is retired. And this firefighter claims that he was discriminated against.
It's a she.
I'm sorry. She was discriminated against in her post-retirement benefits. So the court has to wrestle with the question, as other courts have, simply put, does the ADA protect retired employees, right, in terms of discrimination? And this court holds, no, the law does not protect retired employees, but it recognizes other courts do believe the ADA protects retired employees. This is why this case should go to the U.S. Supreme Court, and may very well do that. At some point, the U.S. Supreme Court, when it sees the courts of appeals disagreeing with each other, has to say, okay, I'm going to step in for judicial economy. For a lot of reasons, I'm going to answer the question. This is a great question because it keeps repeating itself to go to the U.S. Supreme Court and be decided.
Yeah. And I'm going to tell you, I think the U.S. Supreme Court is going to decide it the exact same way the 11th Circuit did, which you could argue is not an employee-friendly decision. It's an employer-friendly, but I think it's the right decision. It comes down to the definition of who can sue under the ADA is a qualified individual who can perform the essential functions of the job,
right,
without an accommodation. Well, she's not an employee. and she
Right.
can't perform the essential functions. So there's a lot of different ways that this court, as well as the U.S. Supreme Court, could rule in favor of what the 11th Circuit decided here.
And what I think the U.S. Supreme Court would say, in addition to that, is the legislature can fix this. Congress could fix this. If Congress wants to protect those with disabilities as a protected class, which this court, I think for that reason, pointed out, right, says that being disabled is not a protected class. There's a law that protects you while employed, but it doesn't protect you post-employment. I had some other arguments, I'm not going to get into it, that I might have gone the other way on, saying, well, these benefits are generated, right? They're earned when you're an employee, and, you know, but
we get into a discussion in LinkedIn, I believe, on this issue, and someone was raising a question about whether or not Title III and Title II and Title III of the ADA might apply. The government services is Title II, and Title III is public accommodations. And, you know, apparently she didn't argue that, which, you know, maybe it's a procedural error, I'm not sure. But bottom line is, under Title I of the ADA, which is employment discrimination, she really doesn't have standing to bring the action.
Right. And look, so Congress, maybe they'll solve it. Maybe they'll make disability a protected class. That makes sense to me. There's probably someone way smarter than I am to say why they didn't do that in the past. Maybe they didn't need to, but here's a hole, and Congress can close the gap.
You know, they might have thought they did. They had Title I, II, and III, and they probably figured between the three of them, we've created that class. Yeah. But the definition of employee, or who is subject to the ADA in terms of being a potential plaintiff, leaves a gap there for people who are not employed.
Right. So what people should recognize is this is a big hole. Maybe depends where you are and which part of the state or the nation you are. But okay, let's. Why don't you go on to Washington?
Right. Well, one more thing with this, it really doesn't get to the merits of her claim, because if you get to the merits of her claim, the question is, when she was hired. The agreement that she had when she was hired was you get health care until age 65. And then at some point, I think it was 2005, like not mistake, or 2003, they reduced it to 24 months after you retire. And she was alleging that discriminated against her based on her disability. And I think the merits of her case, I don't see her, even if she could sue under the ADA, I just don't see that as being discriminatory. It was unfortunately,
to everybody.
Yeah, I mean, changes in pension programs happened to me during the course of my career as well, and not to my advantage. So they rarely do. But the bottom line is, if you retire before the change goes into effect, you have an agreement, and then it's a breach of contract claim. But I just don't see her prevailing. Even if she could sue under the ADA, I don't see it. I don't see her prevailing.
All right. I'm breaking at the moment. I know we're live here, but my office is near a temple, a Jewish temple, Orthodox temple, and I'm watching bomb dogs from the state police walk the temple. It's a little disconcerting because I'm 10 feet away. But we've had some weird things happen. Anyway, not for this show, but wish everyone to be safe out there. All right, you want to head to Washington?
Yeah, Washington State. Yeah, we've got an IFF local from King County Fire District 45, who apparently are, they're subject to their fire district trying to contract out services. And the way that the contract was going to work was that they wanted another entity to come in, take over running the fire department, but employ all of their firefighters. So it wasn't like they were going to necessarily lose their job, although that's always a question when there's a change in management. But the problem here is the district went out to bid, I guess, or a request for proposals from and I'm imagining it could be a neighboring public agency, but I'm imagining a private entity could come in as well and put in a proposal. But the most serious proposal came from the Redmond Fire Department. At any rate, the union sought an injunction to try to block the fire district from contracting out. And the basis for this is that it has to be negotiated. There's certain parts of contracting out, and in the private sector, there's a ton of case law on contracting out. How much of that is going to be applicable in the public sector is anybody's guess. But bottom line is they're seeking an injunction to block the fire district from contracting out firefighting services to a neighboring community. So interesting case, one that I think those who are concerned with public sector labor law will, it's one of those you should just kind of put a asterisk next to and kind of track where this case goes.
Yeah, agreed. Okay. So now this is a great one because I'm reading Los Angeles, but I'm thinking Hawaii. So here we have a court in Los Angeles has dismissed a case as against Boeing and Boeing's fire suppression contractor from the Woolsey fire litigation. This was this 18? Yeah, this is 18. The fire. And look, I'm going to summarize this. There's a lot to talk about. Only so much piques a lot of people's interest, but the court dismisses it basically in all these cases because, well, we've got Boeing, a landowner, and we've got their contracted employee, the fire department. Let's talk about the fire department first. Both of them, well, as against a fire suppression contractor, the fire department, basically, they say, listen, you didn't owe a duty to anybody. And that just brings up normal duty cases you and I have talked about a million times, that a fire department does not owe any special one-on-one duty to any general member of the public. Even when you call 911 and say, help, my house is on fire, they don't yet owe you a duty. I'm going to say most states, because I don't know if every state has special duty rules.
Not every state does, right?
So I'll say probably the most states, and clearly California does, in where this is, unless there's a one-on-one duty. So unless, for example, to everyone, you pull up to a fire and you see someone about to jump, off their balcony, and you say, no, don't jump. I'm coming for you. Stay there. And then you never go. Right. You're just like, I'm going out for pizza. So that's what it takes. It takes that one-on-one contact and relying on you making a promise that you're going to do something that you don't do. That's what it takes to form a special duty. A normal duty, a fire department doesn't owe a normal duty to everybody such that you can sue them for negligence because they breached their duty to you in providing fire protection. So here, the court, as against a fire suppression, says a couple things. One, they don't owe a duty to the general public. Two, they were contracted by Boeing, right? This is their contract. There's no, I'd say, privity. There's no relationship with anybody. So the fire department is out of this because they owe no duty to anybody. So that's pretty easy, and that is where it should go. And look, this is a big fire, right? To sue a fire department that you didn't put it out, you didn't fight it properly. No way, right? We're just not going to start allowing that. Every fire department would be out of business as a policy matter because, leaving up to a jury is how we could save property or whatever. Just not going to do. Okay, so the next really interesting part is against Boeing, even though this is more of a fire service podcast. But Boeing, they said, listen, you allowed a fire, I think is what they tried to say, is you allowed a fire on your land and then encroached onto our land, spread onto our land, and the court's not going to have that either. The court's saying, listen, you didn't start the fire, you didn't allow the fire, right? You weren't careless in the fire starting. So I'm going to the court dismisses trespass and negligence and nuisance claims because you have to show that what you did was wrong. And here they said they didn't do anything. There's just a fire. Now, what's partly interesting, though, is you have to think Hawaii, because I want to move this to Hawaii. Remember, in Hawaii, what the lawsuits are saying is the electrical company knew that they could start the fire with their electrical lines. That's very different than what's happening here. That allegation, right, is the electrical company could have stopped it and they caused it, and they knew they were going to cause it because there was a fire earlier that day, I think, or that week. So I look at this as if you're looking at Hawaii and say, oh, it's going to be the same thing as Hawaii. No, it's not, because there, at least as against the electric company, those claims are they could have stopped it and they started it, not so with Boeing. Boeing, you just owned the land, right? And this lawsuit's still going on against others.
Oh, yeah, it's going on against the utility, which we see a common theme in these cases is that the fire was caused by an electrical spark caused by a wire that comes down or comes in contact with trees. Okay, so I want to connect this to another, another suit that is going on that we've talked about here. Brad, I'm not sure that you and I have talked about it, but it's one that I'm familiar with in Gatlinburg, Tennessee, where the town or the city of Gatlinburg was basically destroyed by a wildland fire that started in a national park. The allegations in that suit go to the Park Service and their failure to warn the folks outside the district that this fire was coming, and people didn't have an opportunity. There's a number of people killed, massive destruction of a city, of a small city. And it was on a hilltop, and the fire just burned up the side of the hill and destroyed the city. But that case, if you get my newsletter, one of the articles in Beyond the Blog, you'll see this week, has to do with some decision making in that, and some of the allegations, some of the judicial narrowing of the allegations in that case. But very interesting case. So I think when you start, like, in this case, if they had been able to prove that something that Boeing did, such as not reporting it to the local fire department and not getting resources involved, or trivializing it, saying, no, we've got it, we don't need any outside resources, you might be in a different situation. But here, just being the property owner and having a fire that you didn't start, right. There's really no duty to third parties who may be injured as a result. Interesting area. And obviously, as you suggest with the Hawaii fires, the Maui fires, we're going to be seeing a lot more of this kind of decision making related to who is going to ultimately be responsible.
So I do want to ask you, because you've been following all these cases for many years, are you seeing obviously we're seeing more wildfires, go on for whatever reason, but are you seeing an uptick in these types of litigation? Because they're not successful generally.
Well, I kind of go back to when I was in law school. There was a lot of tort cases against auto manufacturers and over crashworthiness, and they were largely not successful. Go back even before that, lawsuits against cigarette companies, largely not successful, right? Right up until
they are.
The attorneys learned what to do. They lost the first 100 cases, okay? But there are these law firms out there, and they focus on this, and they lose one. Oh, okay, we learned a lesson. We learned another one. We learned another one, to the point where the tobacco industry is, you can see where it is. Right. The auto industry, as a result of the plaintiff bars actions, forced the auto industry to do things like anti-lock brakes, airbags, not optional. You don't have to pay an extra $3,000. It's built in because they were tired, and crashworthiness standards and all the rest of that. So I see that model being applied here in the wildland. And that's another reason why they've really zeroed in on the utilities, and they put some utilities into bankruptcy as a result of this. And so I think the word is out now to utilities that you've got to get your act together, and you can't be worried about trying to get executive bonuses and different things, and trying to stay within your budget and all that at the expense of public safety. Right. That you've got to start addressing this stuff. I
would almost say this may start to be akin to potholes. You'll see where I'm going in a second. So potholes, there's no liability until you call one in. I'm wondering whether you're going to see these third-party naturalists, go out and say, danger, call it in, danger, call it in. Now you've changed it, because now that you have knowledge and you had time as a utility company to cut back the trees, and if you don't, right, then there could be liability. It's not
Yeah,
you owe a general duty to this massive area. It's I pointed out a problem, you had reasonable time, you did nothing like it.
Absolutely. And there's also equipment, and the equipment is not cheap. Okay. But when a wire goes down, there's equipment that will de-energize, or you can say, well, we can't afford that. In which case, guess what?
Right.
You're going to
look at the executive bonuses to
this
see
one.
maybe you could afford
I just want to get this right. This particular fire, the Woolsey fire, there was
like 29,000 acres or something, right?
1,643 structures.
Wow. Yeah.
And killed 3 people. So you are not going to have something like that happen, and you're not going to be liable.
Right. Or at least,
so,
sued
right. So you can save a little money on your hardware and your different things and not have all these safety features built in, just like the car manufacturers. Okay. You can try to save some money on one end, and if you do, congratulations, you're going to get your annual bonus. Congratulations to the president of the utility and all his staff. But guess what? A couple of years later down the road, that decision may pay another, may have to result in another problem for your organization. So
wait till the fire departments, if they're smart, I got to tell you, if you had time and you could walk the power lines, which would be very tough for a fire department to do. But if you pre-planned the power lines and called in, hey, there's a power line here in connection with a whatever, then the fire department could sue for overtime and all those things. And look, I think the states can do something. I think the states, and some have, New York does a little bit, where they have statutes to say if there's a type of response that takes so much overtime from the fire department, somebody has to pay.
Yeah, California has that.
Legislate a solution if it needs a solution to the utility company saying, well, if a line starts because a utility, electrical line, whatever, it doesn't matter about fault, the utility's got to pay for the fire department.
Yeah.
That would at least be a way to cause some action.
California has that. Number of other states have that in terms of cost recovery. So, yeah.
Okay, let's finish up in North Carolina. This is sad. This is the day that this is just where we are. But there's it appears that there's a fire department, volunteer fire department, who's just not able to do what it needs to do. And so I don't know why it gets to this, because I don't know North Carolina's law, but a county has filed suit against a volunteer fire company, alleging that it's breached its contract to provide services to meet minimum performance requirements. Now, performance is the word we're going to focus on, because they say, look, you don't have adequate staff. That I can understand. But one of the allegations they say is that you don't have a vehicle that carries 1,000 gallons of water or bring 1,000 gallons of water. Now, that's fine if you're in hydranted districts. A lot of these places only have 300, 500 gallon engines, right? Where I am, we have 1,000 gallons because we have a lot of non-hydrant areas. But so maybe it's the fact that they're non-hydranted, they don't have anything to get enough water, whatever that is. But I'm surprised it's a vehicle issue as well as a staffing issue. Normally you just see, okay, you don't have enough staff, you're not getting out. If that's the case, the fire department should look to merge or whatever. If they can't get out, they can't get out. It's just the unfortunate sign of the times we're at. And I'm assuming, I have no idea. I'm assuming there must have been some discussions prior to this between the county and the fire department saying, what are we going to do? You hope so. I have no idea, but you're going to see a lot of these. There's a lot of fire departments. You're going to see a major one coming out shortly. I won't comment anymore on that, but you're going to see a major one coming out in New York State. Similar, where a fire department saying we can't cover a certain type of facility, and it's not a failure in this case on the fire department, but we are seeing, look, buildings are getting bigger, more complex. Electric vehicle fires are a whole, right? Lithium ion batteries are a whole new game, and sometimes these fire departments can't manage. If you have a nice rural area and you're doing 50 calls a year, and all of a sudden a hotel goes up in the middle of your area, you just changed your fire protection needs. Right. And the fire company can't service that. I'm not saying that's what happened here, but in some sense, that's what happens. Or it's the opposite, that everybody's abandoning your area. There's nobody left. You have the fire protection contract, but you don't have people because everyone's moving. And people just aren't volunteering as much as they used to. So I feel for the fire company. I feel for the county. Not that this podcast is about feelings. But nonetheless, this isn't unique. I'm concerned. I'm confused why it has to get to a lawsuit. Why the fire company either admits we can get out or we can't get out. It just numbers don't lie. You're either turning a wheel or you're not.
Yeah, I think there was the reason for the lawsuit was they wanted to, at least from the news article, and I searched for the case. I tried to find the complaint, I couldn't find it, but I think there was some concerns about dissipation of assets and trying to control where the equipment went and stuff. So they want an injunction to basically preserve what's there for then whatever's going to happen after this, if it'll be a new department, new leadership, a merger or whatever it may be, but they didn't want to see the stuff start to disappear. I think
that makes sense.
That
makes sense. A lot of volunteer departments believe that they own the things, that even though they're incorporated, that, well, when we dissolve, the members take all the money. And I will tell you, that's probably 8 out of 10 people I speak to.
Really?
Oh, I'm not kidding. I don't mean 1 or 2 have this dumb thought.
They're not up on the IRS code, are they?
No, and yeah, and in New York State, it's even worse. You'll go to jail, as I'm guessing in many states, if you try to take the money from this corporation. But these are public funds or public trust funds. You can't just take them. But there are, I'm telling you, it is the serious majority of people in a fire department who believe this is our stuff and we will take it when we leave.
Well, you raise a good point. I know you've got a class coming up on volunteer fire company bylaws, and the IRS, I forget when. I was an attorney, so it was after 1985, but the IRS came out with new regulations and things that have to be in your bylaws. I think also your charter.
A lot of those came out during the Patriot Act after 9/11.
Yeah. And so there are things. So, and that what you're suggesting flies in the face of what the IRS is saying, that if you're a volunteer fire company under a 501c3 or 501c4, you cannot just take those assets, that the IRS, and then if not, you can lose your tax status, and God help you, if you lose your tax exempt status.
Right. And that happens all the time. That's a big part of our business, is getting that back for these departments. They just don't file tax returns. We're so far off on this, but if you don't file tax returns 3 years in a row, you lose your C3 status, and places just aren't doing it. I don't understand. But here, yeah, if you're a not-for-profit entity of any type, fire department or not, and you're dissolving, that's great, but you better go to a court, the attorney general, whatever in your state says. But if you're a C3 and you look at your certificate of incorporation, your articles of incorporation, whatever they're called in your state, you will see you had to add a line per the IRS after 9/11 that says, upon dissolution, a court of competent jurisdiction will distribute the assets, not you, and it doesn't go to your members. So, okay, so that very well may be exactly what's happening. They're trying to preserve it. A pretty unusual week for us, right? These, and I know you choose the cases, but you chose some good, unusual cases.
Yeah, there's just no shortage of cases. I probably review between 20 and 50 cases a week. There was one that I sent you a copy of it, and we may be covering that again. Some of them are just so complicated. They're trying to provide it. And even that one case, what was it? The
Disability?
Yeah, no, the Woolsey fire. It was so long that trying to condense. You did a good job of sort of getting to the heart of it, but it makes it difficult. And I have to make a decision: do I go with one that's easy, or do I go with one that's really complicated? And some of them get so complicated that, and I don't think the interest level is going to be there among the folks that listen. So I do have to use some discretion in terms of the 5 or so that I cover. But even the ones I don't cover, you'll see them in Beyond the Blog. For those of you who get my newsletter, so you can follow up there. All right, and that's going to do it for another edition of Fire.